I'm Eric Jaffe. I'm chairman of the Free Speech and Election Law Practice Group, and our group is co-sponsoring this panel. So we'd like to welcome you all here and thank you for coming, and encourage you to, if you're interested in First Amendment issues and election law issues, please get involved with the practice group. We could always use more people who are interested in writing or helping out. So contact me, contact Dean Reuter, whoever you like. But if this is the stuff that interests you, and I hope it does because you're here, please get involved. We could always use more folks. My role here today is really to just introduce the moderator. Justice David Strauss is Associate Justice of the Minnesota Supreme Court. He's been so since 2010. He's going to introduce the remainder of the speakers and moderate the panel. The only other thing I'll say about him, because other than him being a justice, which is more than enough for folks to know his credibility, is that he's a former Justice Thomas clerk, which I think is a fine, fine honor. So thank you, Justice Strauss.
Thank you, Eric. I appreciate it. So what we're going to talk about today is First Amendment and its relationship to process, hence the name of the panel, how First Amendment procedures protect First Amendment substance. And we have a disparate group of panelists that are going to talk about various things. So in that sense, this might be a little different than some of the panels. Some folks are going to talk about civil restraining orders. Others are going to talk about evidentiary burdens of proof. But the theme that brings it all together, these are procedures that relate to First Amendment rights. So I think we're going to get a lot out of the panel. And this is something that's litigated on a daily basis, at least before my court. We had a case a year ago dealing with civil restraining orders. We certainly have our fair share of cases dealing with burdens of proof and evidentiary issues. So I think this panel is very, very timely. We're going to start out with Professor Volokh. He is the Gary Schwartz Professor of Law at UCLA Law School. He's a prolific scholar, as you well know, who has authored a number of books and articles on the First Amendment and has a case book on the First Amendment. In addition to teaching courses on the First Amendment, he supervises a First Amendment amicus brief clinic at UCLA. Many of you are familiar with his blog posts on the Volokh conspiracy. So I now turn it over to Professor Volokh.
Thank you. Thank you very much. So the talk is about how First Amendment procedures protect First Amendment substance. And this is an issue that is certainly not new in First Amendment law. In fact, the Supreme Court has been, some of its earliest cases have dealt with exactly this issue. Restraints and injunctions, allocation of burden of proof, and the like. And the uniting thread here is, let's set aside the debate about what the substantive scope of area speech protection is. Let's set aside the question, for example, let's assume there is a libel exception, as the court said there is. Assume there is an obscenity exception. Assume there's an exception for speech that infringes copyright, or for telephone harassment, or in-person harassment, or something along those lines. What procedural rules constrain the ability to restrict the speech? Just because, for example, there's a defamation exception, does that mean you can get a preliminary injunction against defamation? Does that mean you can have criminal punishment of defamation? Does it tell us anything about who must bear the burden of proof in defamation cases? And the same for the other areas. Turns out to be tremendously important, both as a practical matter as a conceptual matter. And my job here is just to outline the basic shape of the issue and maybe identify a few modern hot points. So classic example is the prior restraint doctrine. Dates back in American case law at least to 1839, probably earlier. And in fact, it used to be actually a very important rule back when there was very limited protection against criminal punishment or against civil liability. There would be very strong protection against injunctions. Today, there's actually weaker protection against injunctions and much stronger against civil and criminal liability, so the doctrine is perhaps less important, but historically has been very significant. And again, it's about the procedure. Which way can these restrictions be had, and not just about the substance. What is the proper scope of defamation liability? The vagueness doctrine is another example. Overbreadth doctrine is quintessentially procedural rule. It says, look, you can challenge a statute on its face as overbroad even though normally in other areas of constitutional law you wouldn't be able to because you could only challenge it as applied. And the premise of this exception, excuse me, of the doctrine, which is an exception from standard rules, is First Amendment rights are so in danger of being chilled, so in danger of being deterred by overbroad restrictions, that we will allow even people whose speech might be restrictable by a narrow law to also challenge the broader law as a way of protecting others, protecting third parties whose interests are being asserted here from the chill of the law. Standing for pre-enforcement challenges. This is important because this is Susan B. Anthony list case just last term reaffirmed that there's pretty substantial pre-enforcement room for pre-enforcement challenges. You don't have to wait until you're being prosecuted for something. At least in many situations, if it seems quite likely that you would be prosecuted for speaking, you don't have to risk prison in order to bring the challenge. Burden of proof. As I'll mention shortly, there are in some cases, libel cases are a classic example, but there are others as well, in which the court has said the plaintiff must prove the falsity of a statement as opposed to the traditional rule, which is a defendant must prove its truth. Quantum of proof. Actual malice in libel cases must be proved by clear and convincing evidence, also an important procedural protection. Finally, independent appellate review, and penultimately, independent appellate review, in which when there's a question of whether some facts that have been found as to what was said, whether that constitutes libel, whether that constitutes fighting words, whether that constitutes obscenity, is to be reviewed not differentially, the way that application of law to fact sometimes is, but de novo by appellate courts and even by the trial court reviewing the jury verdict. And the last one, and it has a question mark to it, is, are there any limits in criminal prosecutions? Is it the case, for example, that even though civil libel liability is permissible, criminal is not? A few quick descriptions of how these things play out today in areas where they're particularly salient. So one problem that we're facing with the prior restraint doctrine, and there are cases coming up every year about this. There's one particularly interesting one from Texas, is that it's just not clear what constitutes an unconstitutional prior restraint. A traditional explanation was if something is criminal liability or civil liability, that punishes speech after the fact. That's impermissible. I'm sorry, that's impermissible. So that may be permissible. But a prior restraint restricts speech before the fact. That is impermissible. There is a line from, I think, Chief Justice Berger in Nebraska Press Association, subsequent liability chills, but a prior restraint freezes. Nice sounding line. But at least ever since the 1950s, the court has recognized at times that, in fact, there's not that much difference between these quintessential subsequent punishment and prior restraint. Criminal punishment and civil liability disturbs speech before it is said. That is, in fact, the purpose of such liability often. On the other hand, injunctions are enforced after the speech is said. There are a few situations when an injunction may actually prevent speeches, when they seize copies of the material. But often the injunction says, you will be criminally punished if you say this. The law may say the same thing. What's really the difference? So what it seems to have come out is that restraints prior to finding that the speech is unprotected are likely unconstitutional. So a preliminary injunction is unconstitutional because it's prior to a judgment on the merits that the speech is unprotected. It's based only on a showing of, say, probable cause or likelihood of success on the merits. But what about permanent injunctions? Most courts that have dealt with this have concluded, much to the surprise, I think, of many who have been following this, that you can get an injunction against libel. The old rule, equity will not enjoin a libel, doesn't seem to be the rule anymore, at least in many states, after there's been a finding on the merits that speech is unprotected. This actually ends up being pretty important, especially in the internet age, when a lot of the speakers have no money. So they're not much worried about the threat of civil liability for defamation. Often the only way to get the material taken down is through an injunction, once it's found the material is defamatory. Query whether that's still a good ultimate balance. Maybe you should be limited to damages as a plaintiff, even if you can't recover those damages. But a lot of people are seeking permanent injunctions these days because they're against people for whom damages don't mean anything. The damages don't have much of a deterrent effect, whereas an injunction would. What about limits in criminal prosecutions? Justice Stevens actually argued that criminal obscenity law was unconstitutional, even though civil obscenity law was constitutional. He didn't join Brennan and Marshall and Stewart, and I think at that point it was maybe, in any case, no, I'm sorry, at that point it was Brennan, Marshall, and Stewart by the time Stephen joined the court that were the objectors to obscenity law altogether. He took the view that obscenity law was permissible, but criminal laws just didn't provide enough notice, that you just shouldn't be held liable for conclusion the speech appeals to the prurient interest and violates contemporary community standards because it's too hard to tell whether it does or it doesn't. But he lost. Interestingly, he lost. And a lot of people assume that criminal libel is also unconstitutional, but the court, the most recent time it visited this question, 1964, simply said it must satisfy New York Times v. Sullivan actual malice standards when those are applicable. So there's been an interesting recent study that in Wisconsin, this varies a lot by state. Some states don't have criminal libel laws. Some never enforce them, but Wisconsin apparently does. And every year there are several prosecutions. And the study suggests that they're good prosecutions. Again, in the internet age, when there are no, defendants have no money often and plaintiffs have no money, the only way to vindicate the person's reputation, the theory goes, is by the prosecutor stepping in and prosecuting the defendant for libel under the proper standards of proof and mental state and such. But if that's proven, then some modest punishment from criminal libel, the study claims, and Wisconsin courts seem to agree, is constitutional. Query whether that's right. The other interesting question is how far it should go. A lot of recent laws having to do with things like so-called cyberbullying and the like, and supposed stalking, actually criminalize things that might be actionable under the tort of intentional infliction of emotional distress, or might be actionable in disclosure of private facts, torts that we had long thought were only civil, but now are potentially being made criminal. So one interesting question is, are there limits on criminalizing that kind of speech? Perhaps because the definition of the tort is too vague for the criminal law, or can that be criminalized as well? Burden and quantum of proof, I already mentioned. Actual malice in libel cases must be proved by clear and convincing evidence. Falsehood must be proved by plaintiff. Interesting question, how much should that apply to other elements of other speech restrictions? Should, for example, by analogy, in copyright cases, absence of fair use be something that the plaintiff must prove, as opposed to fair use being something the defendant must prove? In non-advertising, non-commercial speech trademark cases, of which there are quite a few, some of them trademark parody cases, should there be a showing of clear and convincing evidence as to likelihood of confusion and not just preponderance of the evidence? And finally, let me close with one thought I had about some of these rules. Not all of these rules, not all of the times, and I don't think deliberately on the court's part, but one function, even if not the purpose, but one function that some of these rules have had. And that has had to do with quality of lawyering. I'm pleased to have very high-quality lawyers here. Lawyers who, in really good First Amendment cases, can make really good arguments. And what happens with some of these rules is they help bring in high-quality lawyering into situations where there would be no lawyer, or perhaps a lawyer who is not knowledgeable enough on First Amendment law. And I have two particular examples. One is the prior restraint doctrine. One of the functions that it has is by limiting injunctions, which can be gotten without a defense lawyer. It makes it more likely that a lawyer will indeed be available. One of the things that I think Aaron is going to touch on is in a lot of these restraining order cases, what happens is that there's a restraining order issued against someone, sometimes a very broad order, sometimes an order, do not say anything about the plaintiff who is upset at what she claims is cyber stalking. You cannot say anything about the plaintiff. Pretty clearly unconstitutional, at least it seems to me, but at that point it's a civil case and there's no lawyer involved. And the defendant may be unable to challenge it, may not even know that there's something there to be challenged. Then, if the defendant is prosecuted for contempt of court for violating the injunction, at that point, in many states that follow the collateral bar rule, the injunction's there, you have to follow it. And the public defender that the speaker gets is no longer able, even if the defender knows about First Amendment law, is no longer able in many situations to raise that objection. The other aspect of this is the overbreadth doctrine, and relatedly, the relaxed rules of ripeness. Allows challenges to be brought by experienced First Amendment litigators and not public defenders. Obviously, these challenges are more likely to be brought by public defenders than by unrepresented defendants. But while many public defenders are very good criminal lawyers, many of them just don't have a lot of First Amendment experience. That's just not something that they do day in and day out. So when the case comes up, they may not be able to challenge the law quite as effectively. Whereas overbreadth doctrine and the relaxation of the ripeness rules makes it possible for experienced First Amendment litigators, Alan Morrison, for example, to go into a state and say, look, there's this statute. It hasn't yet been violated. We don't have to wait for it to be violated and then hear about it and then swoop in and give this person really good First Amendment representation. We can craft ourselves a First Amendment challenge on the statute and bring up the best First Amendment arguments because we know what they are in a way that many public defenders do not. So that's a thought about one of the functions, again, not at all a deliberate function, I think, in the crafting of the doctrine, but one of the functions that at least three of these doctrines, the prior restraint doctrine, overbreadth doctrine, and relaxation of ripeness rules, have played, I think, in improving the quality of First Amendment lawyering before judges, including perhaps before Justice Strauss. So with that, I close, and I turn things over.
Thank you, Eugene. I appreciate it. And just to repeat, there's a lot of seats up front if anyone wants to move up. Although we will not call on you. I am a former law school professor. We have many law school professors up here, so we do have the ability to call on you, but we won't. So our second speaker is Professor Kaplan, who is a faculty member at Loyola Law School in Los Angeles. Just a brief look at his publication list reveals to me why he's on this panel. He's written a number of articles on the First Amendment, including a recent article on free speech and civil restraining orders in the Hastings Law Journal, which I believe is going to be a large part of his topic today. Prior to joining the Academy in 2008, he was a full-time staff attorney for the ACLU in Washington. Please welcome Professor Kaplan.
Thanks very much, Justice Strauss. I'm here to give a case study of a type of litigation where free speech and due process issues interact with each other in all sorts of fascinating ways. And this is the area that I've been calling civil harassment orders. The names are different in the different states that have these, but basically what we're talking about is a statute that authorizes any person to go to court and get a restraining order against any other person on the grounds that the defendant was engaged in harassment. How did these orders come about? A little bit of background on these kinds of statutes. We can actually start with the problem of domestic violence. All right. Before we had domestic violence restraining orders, there was a very practical problem of policing. If there's a call that there's been violence at a house, an officer shows up, he said, she said, how do I know, as the officer, do I really have probable cause to make an arrest in a criminal case? It gets difficult, and so there was a perception that the officers were being too cautious in making arrests. So enter the domestic violence restraining order. This makes enforcement a lot easier. You have a civil action where just by a preponderance of the evidence, you can get an order that says the defendant has to stay so many feet away from the plaintiff. At that point, enforcement becomes really easy. You know, all you have to do is say, look, I've got this order. It says this person's not supposed to contact me. He contacted me. Really easy to enforce. And in an area where there was under-enforcement, it's a pretty useful thing. So we start with the domestic violence restraining orders. These then get expanded. Sometimes they're people who aren't actually living together or romantically involved with each other who do nasty things to each other. You might have the stranger who just decides to stalk somebody, or you might have a really aggravating neighbor who is doing things to make your life miserable. So the statute said, let's expand it. So you can now get an injunction in about half of the states against someone who has harassed you. Well, what's that got to do with speech? Well, there's two things. One is that the definition of harassment often allows for a finding of harassment based just on speech. I said something that is deemed harassment, now I'm liable, now there's an order against me. So that's one way speech comes in. Second way speech comes in is in the remedy. Depending on how these orders are written, you might have an order that says you can't talk about this person or you can't say certain things. Now, I think a true no contact order, do not contact this person, don't come within 200 feet of this person, that's not really going to be a prior restraint problem. But we do see these orders that say, do not say anything on the internet about this person. I was very honored to have Professor Volok represent me as an amicus in a case that's in front of the Georgia Supreme Court that has exactly that kind of order. Don't say anything about the plaintiff. So what are some of the due process interactions in this type of litigation? Well, one is the vagueness doctrine. Vagueness, any of you criminal defense lawyers know, it's not limited to the free speech context. If there's a criminal law that's so vague that you can't really tell whether you're going to be in legal trouble or not, that's a constitutional problem. So where's the vagueness in these harassment laws? Well, depends how they're written. My favorite one is from Wyoming. Here's the Wyoming statute. What is harassment? It's harassment if, with intent to harass another person, the person engages in a course of conduct reasonably likely to harass that person. Then they give you some more details. I'm editing out a few things here, but including, but not limited to, communicating in a manner that harasses, or engaging in a course of conduct that harasses another person. So, thank you, legislature, that really helped. So vagueness is a problem here. And on a case-by-case basis, we have to work that through. It is recognized in a whole line of First Amendment cases that vagueness raises a particular problem in First Amendment cases that you don't get in your run-of-the-mill criminal law vagueness case. And that is because we're worried about a chilling effect. We don't want, it's bad enough that people don't know whether their conduct is lawful. It's considered worse if you don't know whether your speech is lawful, because then you're going to engage in self-censorship. I'm not sure how much difference that really makes in a case like this if you've just got a bare statute that says don't go harassing people. How do we assign vagueness points to that? Gee, if this wasn't involving speech, I'd say this statute has a 3.5 on the vagueness scale, but now that it's a speech case, I think it's a 4.7 on the vagueness scale. I'm not quite sure how that works out. And there's questions about, all right, well, what kind of speech is this likely to chill anyway? But certainly there's a vagueness problem that is a combination of the due process concerns that we have about fair notice and how does it affect speech. Second, if you prevail, you are able to convince the judge that the defendant has harassed you, you get an injunction. And again, depending on how the injunction is written, it might put certain speech off limits. Professor Volok's absolutely right that there's a lot of different formulas trying to describe what it is to be a prior restraint. I think the way that I like to think about it is a prior restraint is a law where you can get in legal trouble for speaking without permission. If you have to go to the censor and get permission before publishing, or you have to go to the judge to get the judge to lift an injunction against you, you can be punished just for speaking without permission. And that can definitely happen here. So if there's an injunction that says you can't say anything about this person, that's a pretty classic prior restraint. One line that I think needs to be drawn in some harassment cases is to decide whether the injunction is aimed at speaking to the victim or speaking about the victim. Certainly, if someone is stalking you and they are calling you, sending you emails, sending you texts, sending you letters, showing up, sure, there's a lot of speech in there, but basically what we're concerned about is the contact. Don't talk to this person. I don't care what the content is. There's a category of cases that are basically defamation cases. Somebody goes online and says all sorts of mean things about somebody else. And they'll say, oh, I'm being harassed. They're saying all these terrible things about me. Well, yeah, you probably feel harassed, whatever that means. So there's definitely a problem where these anti-harassment statutes are being used, in effect, as defamation laws. Under New York Times v. Sullivan and all the cases that came behind it, we don't want defamation to be an easy kind of lawsuit to win. But you say, oh, this is not a defamation action, it's a harassment action. Now it becomes easier to win. That's a problem. Well, why are these defamation cases, or why are these harassment cases easy to win? Now getting into a third area of due process, which is just sort of regular old court procedures. The domestic violence restraining order was designed to be easy to obtain, and there's some good reasons for that. But they're designed to be set up so that pro se litigants can obtain them. The hearings are pretty fast. A lot of times it's ex parte. It's very easy to get an ex parte equivalent of a temporary restraining order. There's no jury. And the procedures are fast. They churn through these pretty fast. So all of the things that we would usually count on as procedural protections to try to make sure that judges are deciding things correctly are put in peril. All right? What do we usually rely on? We usually rely on lawyers giving the judge an accurate description of what the law is. If it's all pro se, there's nobody there who's going to raise this highfalutin vagueness argument about how the statute doesn't give fair notice. You just have a pro se sort of saying, oh no, I didn't say that, or she deserved it, or whatever. So the judges often don't have the presentations from the lawyers that might help them. And there's also very few appeals. A lot of this has to do with the fact that it's pro se. Part of it has to do with the orders are often, but not always, of a fixed duration, so they can be mooted out on appeal. If you do go on to appeal, then this brings in another one of our First Amendment procedural novelties, which is independent review. There's a line of Supreme Court cases that says if there's a case that has First Amendment if there's a First Amendment judgment that has to be made, was this speech a true threat, for example? You can argue that over again on appeal in a way that a lot of other factual findings or mixed questions of law and fact you don't get argued again. So on those occasions when you can get into a court of appeals, this is an area where, because it's a speech case, you actually have a little quantum of extra procedural opportunity that you wouldn't have in another kind of case. So that's a quick outline of some of the things that can happen in civil harassment litigation, and I look forward to talking to you more about it during the Q&A.
Thank you, Aaron. That was enlightening. Our next speaker is Todd P. Graves, who's a lawyer in private practice with the law firm of Graves Garrett. Before joining the firm, he served as the United States Attorney for the Western District of Missouri. He represents individuals and businesses nationwide before federal and state courts and administrative agencies, and his areas of expertise include white-collar criminal defense, political speech and election law, internal investigations, regulatory compliance, and complex commercial litigation. I will turn it over to Mr. Graves.
Thank you. I appreciate that. I'm sort of bringing the practitioner's perspective to this. I don't spend a lot of time thinking about the broad principles as much as dealing with the nitty-gritty of it. And in the last 2 years, we've handled speech cases, especially in campaign finance realms, probably in a half a dozen or more states. And one of the conclusions that I've come to is that in many election law cases, there are no effective procedures to vindicate constitutional rights. In the election law context, in the practitioner's world, the government shoots first and asks questions later. And there's a sort of a general background now that I perceive among some judges and many prosecutors, many enforcement officials, that money is bad and that it should be prohibited. There's this new term that popped up in the last few years called dark money. It's legal money, but it's dark in some ways, and that term is thrown around quite a bit. And another thing that complicates it, we often deal in state law matters rather than in federal law matters, FEC matters, and state laws are a mess. And one of the reasons they're a mess is every legislator has something that happened to them in the last election that they want to make illegal in the next election. And it goes both ways. So they're freelancing. They're not using, model legislation. There aren't coherent. They are trying to draft legislation that deals with something that a bone that they have to pick. And to say it as boldly and bluntly as I can, many state law regulators, ethics commissions, accountability boards, whatever you want to call it, political practice commissioners are zealots in this area. And they have a particular opinion of the way the law should be. And the flip side of that is many of my clients, whether they're a C3, C4 candidate, whatever, they're also zealots in the matter. They not only think it's legal, they think it's their constitutional, God-given right to participate. I happen to agree with them, but to participate in this way. And so it's not like a murder case. No one says murder should be okay. They say, well, my client didn't really do that, but we all agree murder's bad. In this case, you've got the government official saying this is bad, and you've got the practitioner saying this is good. This is what our government is about. And so they're kind of like ships passing in the night, and especially when you get to the state level, especially when you get outside the ethics commission type enforcement environment, you get into state level prosecutors, oftentimes they have no idea about the nuances of the law. I've had a prosecutor tell me, I don't know about all that stuff you're talking about, but we just kind of think this is bad and it shouldn't be allowed. And, more than one time I've had a dope prosecutor, someone who normally has a dope case, who someone put a file on their desk and now they're a campaign speech prosecutor. And that's something that in the real world you deal with. And frequently, these cases are ginned up by the opposition, political opponents, then they're weaponized with an assist from the media. So you've got a very short period of time that you're dealing with before an election, and these allegations are coming forward. There's little ability to challenge this. So many times when I describe these cases to my friends who are in a more academic environment or friends in the Federalist Society, they'll say, well, that's not appropriate. That can't be allowed. And they're right, but we're not going to get a hearing. It is happening, it is being allowed, and that's what we deal with. These cases, the Susan B. Anthony case is a great case, and Professor Volek mentioned it. But this is before probable cause finding. Susan B. Anthony had a probable cause finding. In the FBI lexicon alone, there's 3 levels of investigation, and only the 3rd level involves a grand jury. There's an informal investigation, a formal investigation, and a grand jury investigation that's also opened up in the U.S. Attorney's Office. And you don't get a probable cause finding until the end of a grand jury investigation. So you're dealing in a realm where there's no judge to protect you in many cases. The other thing that we run into is as this becomes a more contentious area of the law, we've gone from maybe 2 or 3 years ago, we had civil fights that we were having. Now you're having a criminal fight over an area of the law that is not settled. It goes, much of it's federal constitutional law. There are definitely, just read the recent Supreme Court opinions, and some of them seem to be much more liberal in allowing speech than maybe a constitutional opinion of just a few years ago. So it's a murky area, express advocacy, non-express advocacy, all of that, and you've got a criminal enforcement action taking place. The stakes are very high. And in state court, if you have confusing laws, high stakes, important outcomes, and you also have the abstention doctrines, the various abstention doctrines, so the federal courts aren't going to get involved, and they're certainly not going to get involved very quickly. So against that backdrop, you have a quantum of proof, there is no burden of proof, there is no quantum of proof because it's an investigation. And at the same time, and this happens every day, you have patterned leaks from the prosecution and the investigation authorities, and you have timing issues and very little time. I have a case this last election cycle where 40 days before the general election, I had an FBI agent in a state house going up and down the hallway asking where the lieutenant governor's office was because he had a few questions to ask him. And if you don't think that hits the press and has a real effect, then you're not living in the real world. The other thing you deal with is many of you, some of you may have been involved in campaigns. That last 50, 60 days is high compression, a lot's going on. You have some kind of subpoena drop or investigation leaked, and suddenly you have lawyers telling people not to talk. The campaign manager, well, you can't talk to anybody you work with, and that's just not practical. And again, the procedural protections just don't play out. The other thing that you run into is you have donor fears, personal fears in a campaign finance investigation. They fear that they're going to be investigated personally. They fear that their relationships and communications, and who here hasn't written an email that they'd really rather not read themselves again, let alone have other people read? They fear disclosure and retribution, which has clearly happened at the end of some campaigns in the last few years based on their contributions or their involvement. And one of the things that's very real also is the understanding of the organization and the weak points of a particular political movement. That's important information. We just had caucus elections in Congress, and those were behind closed doors. And those were behind closed doors for a reason, because they want to keep private those sorts of weak points and disagreements in some cases. Against all of this, courts are highly reluctant to wade into that charged environment, especially in a very political and tense time. And anytime you get one of these cases before a court, you may have a judge that is the paragon of judicial virtue, and you bring one of these political cases in, and oftentimes they sort of revert to what they thought before they went on the bench. And strange questions are asked, and I don't even think they know they're doing it, but they're moving back to their comfort level, and they're not viewing these quite as dispassionately as perhaps a case on class actions that they would. Another thing, that's one segment of my topic, but the other thing I was asked to talk about was the big stick that the government carries. When you're in any kind of investigation, when speech is involved or any kind of government enforcement, you're dealing with government resources versus private resources. And the magnitude of what can be brought to bear is very different. Oftentimes you have candidates when they're dealing with a government investigation, they can't or won't fight. Again, elections are won by small shifts. They can't take up this battle 30 days before an election. They have to essentially give in or back away from it. They don't want that on their record. They don't want that on their public tombstone. When you do get into a full-blown investigation, it can be highly intrusive and overbroad. Search warrants. Their search warrants are now being used in these types of cases. People are waking up at 7 a.m. in the morning. They're government agents and sheriff's deputies standing outside their door because of a campaign speech matter, because of a donation matter. Those search warrants are sought in an ex parte, much like was discussed a moment ago, in secret environments. So there's no one to give the counterpoint when the search warrant is sought. Another thing that this society has to address is it's a paper case. So if you're going in a search warrant on a gun, this is black letter law, you can't look in a drawer that the gun wouldn't fit in. When you're going in with a search warrant on a campaign finance violation, any piece of paper you have is fair game because it might contain the information they're looking for. So records and checkbooks and family records are hauled out of these houses, and people's lives are sorted through. Oftentimes, they'll go in on a campaign finance violation and do an investigation over here, and they'll end up finding, what have you, something on the computer that isn't appropriate, and people are convicted for things that have nothing to do with campaign finance violations. And there's no practical redress at this, again, long before a probable cause determination, long before you have an identifiable judge involved, these cases play out. Subpoenas issued by a grand jury, federal grand juries particularly I know of, and state grand juries, the grand jury foreman signs them ahead of time and puts them in a drawer. It's not like there's a real considered action as to whether that subpoena can be drawn. Bank records, if bank records are sought, By law, you can't be notified that those bankruptcies have been sought. So there may be a candidate or a 501c4 that have had their bank records pulled, and they have no idea of that. Email providers, again, often there's no notice. They'll have years of emails that the campaign activist doesn't even know about. Moving to the other area, the IRS cases that we're seeing, we represent the NorCal Tea Party Patriots in one of the lawsuits against the IRS. We have the case in Cincinnati, and they ask ridiculous questions about associations and intent of what you're going to do in the future, and those are very intrusive to someone participating in the political process. And against all this, everything I've talked about up until this point is defense, how you play defense on these cases. But sometimes we want offensive redress. We want to go in and hold someone accountable long after the fact. But procedural difficulties when you're trying to defend, but when you're talking about the government, when you're trying to go on the offense, it's nearly impossible. Use the IRS case as an example. Without a doubt, the Inspector General found that the dissenting groups were targeted by the taxing authority for political speech reasons. The government Inspector General found that. Anyone in a law school class would say, well, that cannot be allowed. But to try to do something about that, to try to weave through the procedural roadblocks to seek legal vindication of an important constitutional right may be impossible. Two of the cases in D.C., the IRS cases, have been basically kneecapped already, and the one that we're dealing with in Cincinnati, there are significant procedural roadblocks that we're trying to negotiate. And finally, in closing, what I'd like to say is a win years later. Let's all think about Tom DeLay. He won. He was completely vindicated. And I think he would probably tell all of us that it's very hollow. An investigation many times in political speech cases, campaign finance cases, if it's done the wrong way, the investigation is the harm, the allegation is the harm, long before there's a probable cause finding. Again, as I said before, in the academic context, the answer is clear. You can't do that. In the real context, sometimes you can do that, and you can suffer those consequences.
Thank you. Our next speaker is Professor Destro, who is a professor of law and founding director of the interdisciplinary program in law and religion at Catholic University. Among other notable accomplishments, Professor Destro once served as a commissioner on the United States Commission on Civil Rights. His work spans a pretty broad swath of First Amendment law, including the religion clauses, but also includes the right to free speech as well. Please welcome Professor Destro.
Well, thank you. It's great to be here. And let me first thank a couple of the people on the panel here for the opportunity. I want to thank Eugene for inviting me to participate and for really setting out a really interesting topic. I mean, for someone like me who was involved in the Susan B. Anthony case, you know, we saw this in real time. And I'm going to talk a little bit about, from the lawyer's perspective, about being involved in it in real time. And I thought that Aaron's presentation on civil orders, civil harassment orders, and I know everybody laughed when we talked about the definition of harassment. But in real life, as I tell my students, you can't make most of this stuff up. That the reality is far more strange than anything the fertile mind of a law professor can come up with. So my modest contribution today is going to be to focus on the importance of good lawyering in First Amendment cases. Professor Kaplan's discussion of the civil harassment proceedings underscores the wisdom of the late Justice Brennan's observation in Spicer versus Randall that the outcome of a lawsuit, and hence the vindication of legal rights, depends more often on how the fact finder appraises the facts than on a disputed construction of a statute or interpretation of a line of precedence. I'd like to make basically 3 points, drawn from my own experience, not only as a professor who teaches both constitutional law and legal ethics, but also as an advisor, kind of in many respects, I call it, to churches, like the church as a regulated industry is the way I describe it. And the most, in my view, is that the most basic due process issues are the ones that occur during the pleading, advising, discovery, and pretrial motion stages. And so I'm going to make three basic points. The first is the most important, and so I'll discuss it last. And that is that ineffective assistance of counsel is as much an evil to be prevented or avoided in First Amendment cases as it is in criminal cases. Second, practicing lawyers often do not understand the process by which constitutional facts are pleaded and proved in First Amendment cases. And then lastly, and perhaps non-controversially, the problem begins by the way we teach Constitutional Law 101. So I'll take these issues in reverse, as I said. So let me start by asking a question. What are the basic skill sets that students should acquire in Constitutional Law 101? I think that nearly all of us in the room today would agree that many students find constitutional law to be a difficult subject. Many find it extraordinarily difficult to grasp what Justice Brennan described as, quote, the complex strands in the web of the freedoms which make up free speech, unquote. They also find it very difficult to understand the relational nature of constitutional disputes captured so well in Robert Jackson's three-part analysis in Youngstown Sheet and Tube versus Sawyer. First and second year law students, at least in my experience, prefer rules. As we try to teach analysis, history, and our thoughts about the roles of judges in democratic republic, they're using commercial outlines to teach themselves the rules. Unless they've been given an opportunity to work on a real case, or at least to work on a hypothetical that is based on a real case, they're not going to really, they will understand the first part of Robert Jackson's observation that constitutional lawsuits are the stuff of power politics in America. But many of them will have virtually no understanding of the important role that lawyers and plain old civil procedure play in the process. Jackson put it well at the end of that quote when he said, "The politics of power is a most important and delicate function, and adjudication of litigation is its technique." So any experienced constitutional litigator knows that standards of review are not black-letter rules. They're instructions to lower courts and trial counsel on how to draft pleadings, conduct discovery, and present evidence. This is why Professor Philip Bobbitt, a number of years ago, suggested that we might want to reconceptualize what a constitutional law textbook should look like. Right now, they're collections of heavily edited cases that are often short on the facts, and they emphasize what appear to the untutored to be black-letter rules. He suggested that we might want to consider reimagining law school textbooks along the lines of business school casebooks, and that way to teach people how to deal with real cases. So viewed from this perspective, a case like Iqbal versus Ashcroft is not simply, as most cases students learn it, a civil procedure case involving the sufficiency of a pleading under Rule 8, but it is a statement by the court about the nature of the evidence that must be pleaded and proved in order to make a case for civil liability on the Constitution, under the Constitution, on a senior officer of the United States. Nor is United States versus Lopez a case about the nature and extent of congressional power under the Commerce Clause. That's one issue. It is, to be sure, a Commerce Clause case, but to a trial lawyer, it is or should be about the jurisdictional facts that show by a preponderance of the evidence whether the defendant or his goods have moved in or utilized instrumentalities of interstate commerce. Cases such as Iqbal and Lopez are much easier to understand and to teach if they're put into the procedural posture in which they arose. A series of short problems that ask the students and professors to view the case from a litigator's perspective or an advisor's vantage point would go a long way to improving and defining learning outcomes in constitutional law. I might add, as I might add in view of Todd's comments about the real world, it would also eliminate, I would think, what a Maryland judge told me in a trial one time. He said, "Why are you quoting the Constitution of the United States? This is Western Maryland." So he said, "Let me give you an example of what I mean. One of the first exercises I give my students in constitutional law is to write a letter to James Madison on behalf of William Marbury, demanding the delivery of the commission that had been signed and sealed but not delivered before John Marshall left his office that night. Their initial reaction is to be nonplussed. They thought that Marbury versus Madison was about, quote, the power and duty of the judicial branch to say what the law is. Well, it is about that, but it's also about William Marbury, his commission, and the remedies that might be available to him under the circumstances. Okay, the second point, and that is, a lot of times practicing lawyers just don't understand the process by which you put a case together. Now, the second point is really that the way we teach con law has a profound effect on the way people practice it. Okay, and this is a problem. Students need to understand how the cases they're reading got to the court. In order to do that, they have to think like lawyers. And we have to train them to think more about their clients than about the rules of law that they're trying to establish. Okay, and so imagine, if you will, I want you to do a little thought experiment with me. If the year's 1993, and you're standing, as I was, in front of a room not unlike this, full of lawyers who represent churches and religious organizations. All of them are trial lawyers. My job was to explain to them why churches were losing nearly every time they raised the First Amendment as an affirmative defense in cases involving sexual misconduct by clergy and other employees. Fast forward to 2005. You're the lawyer at the Christian Legal Society who's considering what stipulations might be drafted in order to make the case go a little faster and be litigated a little cheaper. Should we agree that the University of California Hastings policy was really all comers, that is neutral, or should we start the long, slow slog through the depositions of the dean and the others who crafted the policy? Fast forward again to 2014, and you're advising a group of religious universities here in Washington, D.C., who are looking at new legislation, that is going to penalize them for being religious organizations and teaching their views of biblical morality. In those cases, the due process issues start early and often. You have to show exactly what it is that the client needs to do and basically show them how to do it. I'm going to close by making the last point, and that is that ineffective assistance of counsel is as much an evil to be avoided in First Amendment cases as it is in all others. And I'm going to give you a quick example. And that is, it's taken from the record of one of the most significant Establishment Clause cases in the last 50 years, Zellman against Simmons-Harris. At issue was the constitutionality of a school voucher program that allowed a limited number of low-income kids in the Cleveland School District to attend private and parochial schools anywhere in the state. At the time it was challenged, the court had drawn a distinction between cases in which government programs aid the schools directly and cases in which the parents got the money. Okay, that was the rule. One would think that stipulations on which the trial court based its ruling on the summary judgment motion would have been clear on this point. They weren't. At best, the record was fuzzy concerning how the voucher program actually worked, and the lawyers writing the amicus briefs had to explain it. There are two briefs, I can point them to you in the record, where that story is told, but it's not in the record. Justice O'Connor's concurring opinion tells you how important those facts were. She said, and I quote, "Given the emphasis the court places on verifying that parents of voucher students in religious schools have exercised truly private choice, I think it's worth elaborating that the inquiry should consider all reasonable alternatives and to learn about how the Cleveland School District actually functions." The remainder of her opinion, her concurring opinion, and her vote was not based on theory. It was based on the plain old facts of the case. And she took a sideways swipe at Justice Souter, who dissented, by saying, it's time to place the broader factual perspective the alarmist claims about implications of the Cleveland school voucher program in these cases. So I end by telling you that, look, due process starts with good lawyering. You know, not everybody who gets out of law school is qualified to litigate a constitutional case, but I'll tell you that we need to have, and the Federalist Society, I would suggest here, might want to start sponsoring some CLE courses on how to litigate constitutional cases, because we need it. Thanks.
Thank you, Professor Destro. Anchoring our group today is Alan Morrison, who is the Associate Dean for Public Interest and Public Service at GW. For most of his career, Dean Morrison worked for the Public Citizens Litigation Group, which he co-founded in 1972 and directed for over 25 years. Among other courses, he teaches civil procedure and election law, and I think it's fair to say that there are very few areas of civil rights law where he doesn't have at least some experience. I will turn it over to him.
So I want to begin by telling you how I start my civil procedure class, my constitutional law class. I tell my students I'm going to change the name of the law school. And they look at me and I say, I want to change the name of this place from the law school to the fact school, because facts, as Bob just mentioned, really do matter in everything we see and do in the law. And so the question I want to address today is, how do we show or prove facts in First Amendment litigation? Sometimes it's easy when the plaintiff has a case like O'Brien. You know they burned the draft card. That's not a problem of proving it. You know you want to make a contribution above a certain limit. That's easy to prove. What's harder to prove and thinking about proving is how does the government prove its justification, or how do you, as opposing the government, try to respond when the government asserts certain interest as being their justification? So I'm going to take the easy way out and talk about a case that I'm currently litigating in the D.C. Circuit en banc that was heard late September, called Wagner against the FEC. This is a case in which Congress has passed a statute, 2 U.S.C. 441C, in which it forbids any individual who has a contract with the federal government from making a contribution in connection with any federal election to the president, member of Congress, political party, political committees, ideological or otherwise. Can't make any contributions whatsoever. It applies to challengers, it applies to minor parties, it applies to candidates, and everybody. Under the federal system, the only candidates for federal office are the president and members of Congress. But they have no authority under federal law to write any contracts. Occasionally, Congress will pass a bill that has a contract in it, but that's by far the exception. Most contracts are written and approved by administrative officials at the agencies under very complicated and detailed laws dealing with government contracts. So I have 3 plaintiffs. One of them was a law professor who had a consulting contract with the Administrative Conference of the United States, for which she was paid $12,000 for writing a 144-page paper and attending about 10 meetings. The other 2 are former employees of USAID who took retirement and then were rehired as government contractors, sitting next to the very people they sat next to before, doing essentially the same kind of work that they did before when they were employees, when they were allowed to make contributions, but now that they're contractors, they can't make contributions. Corporations, which is what I always thought were the major persons affected by this, can't make contributions themselves, but they can set up political committees. Their political committees have to bear the name of the corporation, and the corporation can solicit and pay for the solicitation of stockholders and officers of the corporation who can give to the political committee, and the political committee can make all the contributions that the corporation can't. So the Boeing PAC, for example, can make contributions just like everybody else can. And of course, so can the officers, the shareholders. And of course, if you happen to have a limited liability corporation of which you are the sole stockholder, sole employee, you can make the contributions even though your LLC that has the contract with the government can't make the contributions. This applies only to government contracts. It doesn't apply to grants, even though today the federal government spends much more money on grants. There are many more grants that are affected, but it doesn't cover grants at all. And of course, it doesn't cover contributions that are rounded up by people who would like to be ambassadors and who actually make large donations through their bundling and get to be ambassadors. That's okay as long as they don't do it to get a contract. There's an equal protection claim in this case, but I want to frame this as a First Amendment analysis. And I'm going to assume that strict scrutiny doesn't apply and that all that has to be shown is the appearance of corruption. Now, the question is, how can the government prove the appearance of corruption? Now, in some cases, such as McConnell against the FEC, in the part of the case that dealt with the party rules, there was actually a lot of testimony before Congress as to what was going on, why the sponsors of the law wanted to expand the coverage to allow only certain kinds of contributions to be made by the parties. And members of Congress, who are actually experts in this area, testified about it. And then there were some people, like lobbyists and others, who, as someone was wanted to say, committed truth by telling them what they really were doing with this money when they gave it to the political parties. So in that case, you actually had some evidence. The problem was, in this case, this law that I'm talking about was not some recent amendment to the U.S. Code. This law was passed back in 1940, at a time when there were very few government contracts, although there were enough to be worried about. The coercion was already prohibited at this time, and there were some evidence of scandals, mostly people who were being asked to contribute to the Democratic Party or to buy advertisements in the Democratic Party book, who were buying books at way above the market price of the books, and that was plainly an effective contribution. Nobody ever considered at the time actually putting a limit on contributions. They just said you can't do it at all. And if you read the legislative history, there's some wonderful quotes in there from members who quote Justice Holmes, who said you have a constitutional right to be a policeman, but you don't have a constitutional right to speak if you're a policeman. And they thought that applied to government contracts. You may not have you have no constitutional right to have a government contract, and you certainly don't have a right to speak if you have a government contract, and we can penalize you by putting you in jail. All right. So the question then is, do you have to show the government, have to show some kind of scandals? And if so, what kind of scandals? Well, there's no evidence of this, of course, because there's been the law has been in effect for many years, although I have to tell you this, a number of my colleagues, including some of them who teach government contracts, were unaware of this law until I called it to their attention. In fact, they were much more worried about being sued over the law than they were worried about being a plaintiff in the lawsuit and having the FEC discover that they actually made contributions at a time when they were not supposed to be making them. So how do we try to show this, or does the government have to show it at all? Can they just simply say appearance of corruption, or do they have to have some evidence of this? And this being, of course, the contracts that will be made by contacts that will be made through the employees or indirectly to Congress through the appropriation process. We had a couple of people who had been witnesses. One who had run the government contracts program filed a declaration. He was deposed, and in the end he said, sure, anything is possible. There's no way we can rule out the possibility that somebody someday may have made a contribution that might have this indirect effect that may have gotten them a government contract. So the big question was, what does the FEC have to do to prove this thing? And the FEC took the position that it could take legislative notice of legislative facts. And by that they meant they could cite newspaper reports, television stories, criminal cases that mostly were found in newspapers or other places like that, and they did not have to put on any live witnesses that we could examine and cross-examine. They didn't have to put anybody have to be deposed. They didn't have to put any affidavits in. That these were all legislative facts in the context of the First Amendment. I assumed that the facts were accurate. That is to say, they reported what was there. The difficulty is they're only relevant if they have comparable situations to what we're talking about here. And the problem was you couldn't tell from the reports of most of these cases whether the situation was comparable for several reasons. First, because the laws on how contracts are let are very different in the states, which is where they all came from, and municipalities. Second, the campaign finance laws were very different in these situations. And third, often you couldn't tell who the contribution came from. In many of the cases, the contributions came from people who, under the FEC scheme, would be allowed to make contributions, that is, the shareholders and the officers, and not the individual contractors as well. So some of these, of course, were bribes. Criminal convictions under federal laws are different things, and the FEC said, well, this is a scandal, and that's a scandal, and we can use those to do the same thing. And so the real question is, who should have the burden of showing what in a case involving the First Amendment? Should the court be allowed simply to do what judges do in non-jury cases from time to time? And this was, well, this was ultimately a question of law. Take it for what it's worth, whatever that means. In fairness to the FEC, and I hate to be too fair to the FEC, this was 70 years ago that the law was passed, and so we didn't know what was happening. Nothing. It's hard to prove a negative over that period of time. But the basic question gets to the question is, can Congress do this at all? Do they have the authority to make these kind of broad laws? And then what do you do about over-inclusion and under-inclusion? Why are grants not covered? Does Congress have to explain why the grants are not covered? Does the FEC? And what about corporations? If corporation PACs can make contributions, who has the burden of proof, and what do we mean by proving that there's no appearance of impropriety as well? My favorite example in the case, and this is the FEC said, well, you're not completely forbidden from doing this. You can't make a contribution, but you can have a fundraiser. And you can have the fundraiser at your house, and you can invite anybody you want in, and they can bundle all the contributions you want, and indeed, you can actually contribute $1,000 toward the cost of the fundraiser, invitations, food, and so forth, but you can't write a check for $10. That's against the rule. So the question is, who has to justify what in this case? Or should we just simply say that the government has to come forward with real evidence by real people to show the danger in the First Amendment? Or some would say, is that a cop-out? Are you just assuming essentially strict scrutiny without being willing to call it that? My own view is that this is the First Amendment, and that when government is trying to show that something bad is likely to happen, they ought to be able to come forward with something more than rumors and newspaper reports and speculation. After all, we know from the Bose case that courts will independently review findings of fact, but those findings of fact are only as good as the evidence that comes in the front end to prove them. Thank you very much.
Thank you, Alan. So I tried really hard to figure out a question that could apply to all 5 panelists, and I think I've come up with a question that could apply to 3 of them, and certainly the others are free to interject as well. And by the way, after I ask my one question, please feel free to line up and get ready to ask questions because we'll be taking questions from the audience. So this question stems out of our conference call that we had before the panel when we were just trying to decide what to name this panel. And the question is how does due process play in, procedural due process play in, if at all, in these types of questions? And Professor Volokh said, well, not at all. And I found that interesting because one of the questions, and I wrote an opinion last year dealing with orders for protection, and one of the hardest parts of the opinion was actually writing down what the district court had to do on remand. Because we don't have, in the due process cases, we have the guidance of Matthews versus Eldridge in terms of what procedures need to be given. In the First Amendment context, there's really no analogous sort of guidance that the Supreme Court has given us. So how do we make, when we're talking about burdens of proof, applying to certain types of claim, when we're talking about additional procedures, what procedures, how do the courts decide what procedures should apply in particular types of claims? Anyone.
Am I in the 3 or the 2?
You might be in the 3, actually.
All right. Well, as I've indicated, I do think that we ought to start thinking about these proving issues of fact by the way we prove them in the old-fashioned way, at least in the first instance. And maybe we should have some greater relaxation at the edges, but we at least ought to try to get witnesses on the stand, or at least at deposition, to say things that people can cross-examine them about, instead of trying to cross-examine a law review article or a learned treatise of some kind, or a newspaper article, or someone's law review. I think we need to get back to thinking about that. I've written a piece in the Lewis and Clark Law Review about that issue in connection with the Brandeis brief, which I got to be looking at, and I wrote it in connection with trying to prove facts in the context of same-sex marriage cases and how they go about proving various kinds of discrimination and justifications. And I found myself very uneasy with how facile some of the efforts were to prove various kinds of issues that were on both sides of the case, and how one should go about proving them. So I think that although the due process clause is not often spoken of in evidentiary terms, I do think it has some resonance, and we ought to think about it a little bit more.
Sure. I think one of the things that I actually like about Matthews v. Eldridge, it's not so much the three-part part of the test, because that doesn't let you do that much. Doesn't draw that many conclusions for you. But the basic idea that we have a sliding scale, that the more serious the deprivation of liberty or property, the more procedures we're going to have. I think that's a good one. That's going to be case specific, so it's hard to draw any great principles, but at least I'm willing to say, yes, I like that idea that the more serious the deprivation, the more procedures we should have. And I am also like the idea that, hey, depriving someone of their freedom of speech is pretty serious. So put those two together. I can't tell you exactly where that leads, but I think those are two general principles that are worth building into it. It's interesting that Professor Morrison mentioned the marriage cases, because it's something that I was thinking about when he was speaking, that I mean, there's been so much legal change in this so rapidly, but in the wave of litigation that was happening 4 or 5 years ago, pretty much all of the cases where there were challenges in court to marriage laws, when they were decided on summary judgment, the government won. And the first 2 cases that actually went to trial, the plaintiffs won, where the government or the interveners who were defending the law actually needed to put on witnesses and say, here's what the government interest is. The judges who actually heard that testimony said, wow, that's really not persuasive. So I want to second his notion that let's get more witnesses involved.
Well, I would certainly second that. I mean, the example that I gave at the end, if you're in the process of advising a client, you know, who's going to have to defend themselves, say, in a same-sex benefits case, you know, you're going to have to sit down with that client and figure out what they're going to say on the stand, you know, and you're going to have to look at very seriously what the government's asserted interest is, and you're going to have to depose a number of people in order to find out how it's going to be administered. That's why I use the Christian Legal Society case as an example, because the case turned eventually on a stipulation that basically proved the case. You know, so I think that the idea is when we teach con law, we teach it in terms of, you know, standards of review and any rational basis, but we never think of that in terms of evidence. What is the basis? Why should we defer? You know, and what do you mean when you say the interest is compelling? There needs to be evidence on all of those things. Otherwise, all the court is doing is citing rules. I'll give you one last example. We did a series of, we did some research a number of years ago on prison cases. You know, and what we found is that every single time the formulation of the compelling state interest test was, compelling state interest and no less burdensome alternative. That meant that the state lost. That when you looked at the cases where there was actually evidence and the state won, they never mentioned the normal standards of review. When you actually look and see about how these cases work, cases on which there's really good evidence come out differently. I think Aaron just made that point.
So I think that's quite true of the cases where the issue is what evidence is relevant. There is this broader question of what procedures you use to discover the evidence and what procedures can you use to restrict speech in light of the evidence. So it's an interesting question. Should permanent injunctions, for example, be allowed in libel cases? Pennsylvania Supreme Court says no under the Pennsylvania Constitution. California Supreme Court and several others say yes. Texas Supreme Court says you can't have an injunction against future speech, even an injunction prohibiting specific statements, but you can have an injunction to take down existing speech. So these are interesting questions. What kind of facts could one come up with to demonstrate this one way or the other? It certainly are interesting factual questions about what tends to cause a chilling effect and what doesn't. It'd be very hard to imagine the social science evidence that would demonstrate that. So I don't know. I mean, I think it's an interesting idea to use Matthews v. Eldridge. I don't think any of those cases, many of which have roots before Matthews, actually use it. But as Aaron points out, it's hard to see where Matthews exactly will get you because that's the nature of Matthews. So I don't know. I mean, this is a very interesting question. And I don't know if there's a general answer to how courts should resolve these questions when you raise the burden of proof, when you change the burden of proof, when you raise the quantum of proof, when you allow criminal liability, when you allow third-party standing. There certainly has been no shared pattern for dealing with these things.
Fair enough. Questions from the audience?
Hey, I'm Hans von Spakowski, served on the FEC, and I do have a procedural question for you. I always thought it was a little odd that, as you know, jurisdiction over going after violations of federal campaign laws are divided between the FEC and the Justice Department. The FEC has jurisdiction over civil violations. The Justice Department has jurisdiction over criminal violations. And my question is this. People have criticisms of the FEC, but the one criticism you never hear about the FEC is that they are engaged in a partisan prosecution. And that's because it takes a bipartisan agreement. You have to have commissioners of both parties agree to pursue an investigation. And that is not true with the Justice Department. The party controlling the White House has the ability, if they want to engage in partisan criminal prosecutions. And I wonder whether you all think that that should be stopped and whether responsibility for criminal prosecutions also should be shifted over to the FEC from the Justice Department.
Well, I'll answer that question. I don't think the FEC should have criminal prosecution authority. It would be a bad idea. There would probably never be another criminal prosecution, no matter what the facts were. But am I right that the Justice Department, at least ordinarily, will not bring a criminal prosecution unless it has been referred to it by the FEC? No, that's incorrect. It's not correct. Okay, I apologize. I thought most of them came that way.
So it's an interesting question, what the policy should be. Another question is there constitutional basis for saying certain prosecutions can only be brought by nonpartisan or bipartisan bodies? That would be a very strange rule under existing constitutional doctrine. I'm not saying necessarily be the wrong rule, but it's interesting. I think some procedural guidelines like that are kind of taken off the table, in part because of tradition, that traditionally prosecutions are brought by executive agents who are responsible to a political official of a particular party. So that's an interesting question that may be more a matter of statutory design than constitutional command.
The opposite position of the one the executive took in Morrison against Olson.
Yeah.
When they said that they had to be done by the president under the president. They couldn't give it to somebody else. That case was an independent
All right,
counsel.
I want to make sure Todd has a chance to respond.
In my experience, I would not want to see that taken over by the FEC because the failings or the shortcomings in prosecution by the DOJ when they happen, I don't think they're a Republican or a Democrat from the top. That department, those actors are very careful about what they do, and out of 100,000 people, it's really only a few handfuls that are actually political one way or the other. I think the real danger of the DOJ is the guy who's laboring in anonymity and suddenly he gets to make this decision. It's made it oftentimes at a very low level by someone who doesn't really have a good understanding of the campaign finance issues, and that's the danger more than the Republicans want to get the Democrats and the Democrats want to get the Republicans. I think many times it's sort of the government official kind of wants to get people who are spending a lot of money in politics is more of a danger.
All right, next. Oh, do you want to?
I had just one little point, and that is, picking up on Todd's point, is having been involved in a case that had a lot of political angles to it. You know, a lot of the problems we saw actually were more legal ethics, prosecutorial discretion questions than they were, you know, problems of proof. I mean, the prosecutors didn't actually care that they couldn't prove the case. They had their guy, and they were going to have the pelt on the wall. So, you know, so these legal ethics questions actually kind of, you know, why is the prosecutor picking this case, and do they have the facts to do it? It was amazing. At that lower level of attorney competence, how cases get screwed up.
Next question.
Nick Rosencrantz, Georgetown Law School. Several panelists have made reference to ways in which the First Amendment is unique, doctrinally unique, and then theoretically unique. For example, overbreadth doctrine, third-party standing doctrine, things like this. And as a matter of the rationale for the First Amendment, this idea of chill, that we're particularly concerned about chill in the First Amendment context and maybe more than in other contexts. The panelists, though, have not made mention of the unique grammar and text of the First Amendment. So the First Amendment, unlike the other amendments of the Bill of Rights, written in the active voice and says, Congress shall make no law. Is there some relationship between the unique text of the First Amendment on the one hand and some of these unique doctrines that we've heard you talk about on the other hand?
Anyone want to take that one?
So much as I admire my co-blogger Nick's work on this, I'm a little skeptical about it for a couple of reasons. One is actually a lot of these things are filtered through the 14th Amendment, of course. So the great bulk of the cases, the First Amendment cases, are cases involving restrictions on state and local law. And so there the relevant provision, depending on how you read it, is either that no state shall deny people a due process of law, or deprive people of liberty.
It says passive voice, no person should be deprived of life liberty.
Fair enough. I'm not sure that should matter, but maybe Nick might disagree. But in any event, it's the same language that applies, that incorporates the First, Second, Fourth, and such amendments. I will also say one thing that struck me in doing the very limited historical research I've done on original meaning of the First Amendment, which I've done in the area of symbolic expression, civil liability, and freedom of the the scope of the Freedom of the Press Clause, is that how similar many people of that era, not everybody, and you see some arguments about this made in the Sedition Act debate. So I acknowledge this isn't everybody, but lots of people during that era viewed the First Amendment as very similar to state constitutional provisions on speech and press, mostly press, a lot more press than speech. And those were written grammatically quite differently, and in fact, in many ways, quite similarly to other constitutional protections in those state constitutions. So that's what makes me hesitant to think that the particular text of the First Amendment as such, notwithstanding the similar treatment of similar provisions of the state constitution and the similar filtering of that through the 14th Amendment, that should affect the way we think about First Amendment procedures.
I would also add that textual focus would mean that the president and the courts could issue rules and make decisions based on anti-First Amendment values I think that's a danger.
I'm going to disagree with you just a little bit on that one. That I think one of the easier ways to look at that question is via legislative jurisdiction. I mean, the fight over the First Amendment really anticipated McCulloch versus Maryland. And so that, under McCulloch, if you could have a bank of the United States, you could have a church of the United States. For exactly the same kind of reasons. They wanted assurances that Congress couldn't do that kind of thing. And that's why I think Hamilton's point about not having a particle of spiritual jurisdiction, is jurisdiction is a good way to think about it. And now it's coming back in terms of the expansion of the administrative state, going into the interstices of press and other places and saying, here's how you have to do business, here's who you have to hire, you have to have, et cetera. So I'll leave it at that. Thanks.
All right, let's take one more question, and we'll have to have brief answers because we have about 3 minutes left.
Michael Francisco in the Colorado Attorney General's office. My question is about proving this state interest, these facts that you've talked about. It seems like there's a number of sources to do that. You could point to what other courts have said a state interest is in a particular law. You could look to legislative history. You could hire an expert, or the lawyers could just make it up and argue. And I'm wondering if you'd comment on kind of the comparative value on different sources for proving a state interest.
Well, I guess I would say as far as prior cases are concerned, if they made it up there too, or if the lawyers in that case made it up, that wouldn't, just repeating the same problem from the past. I mean, I think the legislative history is useful in some cases, and we should not disregard it. Whatever Justice Scalia thinks about it as a general proposition, I think in some cases it's useful and more useful than in anything else, because at least it's contemporaneous with the explanation for why they were doing it. But as I say, I would prefer to have something closer to what we would see at a trial, maybe not exactly the same. And I don't have any problem with expert witnesses in the social sciences. They were put forth, as Robert said, in the same-sex marriage cases, and they were debunked seriously by the other side and disregarded by the judges. But at least they've had an effort up there, and I'm in favor of seeing those kind of witnesses on both sides of the controversy when there's disputes about whether a law would have one effect rather than the other.
I just want to pull in Caroline Products to the comments that were just made there. Most of the discussion of that case is about the famous footnote, and it's actually very difficult to figure out from the opinion what was being argued, but what I think was going on is that the Caroline Products Company, they manufactured this product called filled milk. They wanted to put on a trial about whether Congress's finding was rational, and the Supreme Court said, no, you don't have to do that. It's funny, a lot of my students think that the reasoning in Caroline Products actually goes too far. It's like, if every single member of Congress had been bribed, I wouldn't be able to put on evidence of that, and Caroline Products seems to say, no, you can't. But that's what you're up against. Or that's what makes it easy for lawyers to go in and make it up, is what I should say.
Let me just flag one area of concern. I like the idea of evidence being introduced at trial. It sounds much like normal trials. But the next step from that is, okay, this particular one trial judge has heard evidence on whether same-sex marriage is a good idea, or whether some gun control policy is a good idea, or whether some other economic, social, whatever, facts are or are not the case. And now we review that for clear error, because he got to see those experts and squinted at them and said, ooh, I think you're lying. I think you cheated on that. I think your statistics are just bad. Somebody might want to figure that out, and in situations where we don't have deference to the legislature, it's the courts. I certainly don't want it to be, well, you happen to draw this trial judge who happened to draw this conclusion. Now we review that for clear error. That may be perfectly sensible as to, well, did this person pull the trigger or not? Not so good, it seems to me, as to these legislative facts. There ought to be the Supreme Court being able to review those.
Reverse Bose.
Exactly.
All right, I'm under strict orders to keep this on time, so please thank our panelists for the wonderful presentation today.